Good morning.
Good morning.
Names are Isaac Ruto, also Vice Chair.
Thank you.
Good afternoon, my Lord. Jacqueline Ngutia, Commissioner, welcome.
Good morning and thank you.
Good afternoon, Justice Katwa. My name is Caroline Lani. You're welcome.
Thank you and good afternoon too.
Good afternoon, Judge. My name is Charity Kisotu, a Commissioner. You are welcome.
Thank you very much.
Good afternoon, Judge. Omwanza Mbati, karibu.
Thank you and good afternoon.
Good afternoon. I'm Joaquin Dongo, representative of the Supreme Court on the Commission.
Thank you.
Good afternoon, Judge.
Good afternoon, my
Anthony Mrima. Welcome and I wish you the best.
Thank you very much.
Good afternoon, Justice Kigen.
Good afternoon.
Fatuma Sichale, I'm your representative at the Commission. Karibu sana.
Thank you very much.
Good afternoon, Judge.
Good afternoon.
You're welcome. My name is Oluwande Evelyn.
Thank you.
Good afternoon, Judge. Dorcas Odor, Senior Counsel and Attorney General. Welcome.
Thank you very much, Commissioners. Judge Joseph Kipchumba Kigen Katwa.
Yes, my lady.
Could you tell us your county and your ethnicity?
My county is Elgeyo Marakwet and my ethnicity is Keyo.
Very well. Do you know why we ask that intrusive question?
I do, my lady.
Why?
I think for regional balancing and, basically regional balancing, I think.
Is it a constitutional imperative?
Yes.
Which particular article?
I can't quite place my finger on the exact article, but I would say it is intended by Article 10, Article 7283, and Article 236.
Yes, very well. So now we will start. You were here not long ago, and I think the challenges I have is what questions to ask you, because we recently interviewed you successfully for the judge of the Court of Appeal, and you have hardly been there for 3 months. You under normal human HR practice, human resource practice, at least one stays in a job for 6 months to be evaluated for promotion. You haven't been there for even 6 months for promotion. So maybe you can explain this before we go to the questions.
Yes, my lady. I know that you very particularly mentioned the point that I haven't been there for more than 3 months, and that in an ideal environment, I should have waited for a little more time so that there is perimeters for my evaluation for promotion. My lady and commissioners, my understanding of why I am here is different from that. My understanding is that I've come here for evaluation as to whether or not I'm eligible for appointment to the Supreme Court. And that eligibility is not a question of promotion, it's a question of whether I'm qualified. And when I looked at the scoping that was done for a person who can qualify for that office, I thought I met the conditions, and in the circumstances I applied. So, Chair and Commissioners, I'm here very humbly seeking that I be evaluated on my competence to be appointed. And the fact that I may have recently been before you should not be a factor, because I'm not here for a promotion. I'm here for whether I'm competent. I also observed that quite a number of people have come to the Supreme Court directly from outside judiciary. And so judiciary is not necessarily a stepping stone for qualification to qualify for that office. Those are the considerations that were in my mind, Chair and Commissioners. And I say this with the greatest humility.
Very well. Now, then we can come back and forth to that question of, are you happy in the Court of Appeal? Are you satisfied with being a judge in the Court of Appeal?
I am, my lady and commissioners, and thank you very much for having found me deserving to take up that office. I want to express my gratitude to all of you. Yes.
Yes. So now, we want to hear from you why you think this commission should recommend you for nomination of the office of a judge of the Supreme Court. We want to hear what experiences and skills and knowledge you will bring to this court and how you're going to leverage them or to locate these skills within the 5 or so jurisdictions of the Supreme Court.
Thank you, Chair and Commissioners. I consider myself eligible for consideration to the office of Supreme Court Judge on the premises that, in my estimation, I have a feel and experience of all facets of Kenyan, both as a Kenyan citizen and also my competence in legal practice. I grew up in an environment where, in an environment of want, I went to Kiplombe Primary School, I went to Mother of Apostles Seminary, I then went to St. Patrick's High School, then came to Nairobi University, and through all those levels, it was hard work, enterprise, and studies that took me through all that. I then entered into legal profession now for about 30 years, and I have both national and international experiences. I have represented all cadres of people. I have gone to all legal forums and even non-legal forums, and the wealth of all those experiences, my lady and commissioners, are such that I would contend that makes me very qualified for this. A little more on the issues of where I've appeared. I appeared in tribunals, I appeared before commissions, I appeared before magistrates all the way to the Supreme Court. I have represented judges, I have represented advocates, I have represented other people. I mentioned particularly representing advocates and judges just to make the point that those are the best judges of my competence, and if in their evaluation they thought I could represent them, then it is a strong statement of my competence. I think the type of works I have done, the results I have produced, are such that they also strongly comment on my competence. I will not pretend to know all the law, both in terms of statutes or precedents. I will not pretend. But what I can say for a fact is that I have the competence to identify what the issues are, to be able to analyze them, to be able to research and familiarize myself with what I need to determine. And this is born out of experience. I have represented people outside the country where I've had to learn other legal regimes and systems, and particularly the confluence of common law and civil law at the ICC. I have had to study and analyze the operations of sports law and represented athletes on sports law. And the legal regime, I appeared even long before the legal statutes were quite in place in Kenya. And so there was near vacuum on what we need to look out for. And it was through my research and enterprise that I was able to familiarize myself and be able to represent them. I have also appeared in the East African Court in Arusha, and that required of me to look beyond the statutes that apply in Kenya, to look at the statutes that apply in East Africa and internationally. And the accumulation of all those experiences, my lady and commissioners, are such that I contend that I'm in a position to be of service to the judiciary at the level of the Supreme Court.
Thank you very much. We will now move on to another area, and Justice Shale will take it from here.
Thank you, Honorable Chief Justice. Judge Kigen, there are concerns expressed by a section of Kenyans
Yes.
as regards your suitability for the position of a Supreme Court judge.
Yes.
And these concerns were made known to us as the Judicial Service Commission via a letter dated 8th of April 2026, which we have since brought it to your attention. Did you get that letter?
No.
Oh, I'm sorry.
No, I'm hearing it for the first time. But I suspect I know what it could say. Probably just say it.
Okay. Let me just bring to your attention what the section of Kenyans are saying. They're expressing their misgivings about your candidature. Firstly, they are concerned over the fact that you've been a lawyer for His Excellency President William Ruto, and who is likely to be a candidate in the elections of 2027. The fear that these Kenyans have is that in the event that you're successful and you join the 6 judges in the Supreme Court, and then thereafter there is a petition challenging presidential elections for the year 2027, their fear is that you are likely not to be impartial. What do you have to say to this?
Okay, so first of all, it is true I have represented him. May I say that I intend to be as objective and neutral in my discharge of my functions as a judge. And so the fear is, well, I can't say it is ill-informed. I can understand the concerns, but I just want to give the assurance that I would be fair and I would only deal with facts and the law. I would also like to say 2 other things, commissioners. The first one is I am aware that that concern has been, and that's why I was saying I have suspicions that of what the letter is, and I must complain that you didn't share the letter with me so that I would have a more structured answer to the question. But let me just answer to this effect. That I have looked at the totality of judges, right from the High Court, Court of Appeal to Supreme Court. Looking at the totality of them, you would almost say about 50% of them were lawyers. And so for me to be told that you have a disadvantage because you represented a particular individual would be a borderline case of discrimination, because I would be being treated differently just because of the type of the client I represented, when in fact every other person who escalated to the status of a judge who was an advocate is not being subjected to the same disadvantage. And so, commissioners, with a lot of humility, I would pray that first of all, you look at me for what I stand for, integrity, fairness, and justice, and that I will apply the law fairly and objectively. But secondly, that to distinguish me just because of one client, a criteria that has not been applied to other candidates who apply to be judges, would probably not be quite fair. And lastly is that there are measures, if anybody is concerned about my sitting in the bench and as justifiable cause, there are provisions for how that can be handled, including recusal, and I'm aware that some presidential petitions have been done with less than the totality of the 7 Supreme Court judges. And the Supreme Court's workload is not focused or limited to only presidential petition. The other work assignments that the Supreme Court has. And so if it were to be such a significant and weighty concern, I would say there is that option also for recusal. For all those reasons, commissioners, I pray that that should not be used to my disadvantage in this interview. I am glad to answer any specific issues that arise around that issue.
All right. I think we hear what you are saying.
Yes.
But you know, when it comes to the dispensation of justice, it is not important. It's not only important for justice to be done, but justice must also be seen to be done. And given the fact of the office in question, the stakes are extremely very high. And when you tell us, for instance, that there is that possibility that you can recuse yourself, and given that the number is only 7, and you know there are many things that happen in life, people fall sick, etc., etc. So if now we are saying we are going to take you, and then you've given us that undertaking that in the event that there is an objection to your hearing an election petition, presidential election petition, there is that possibility that you can recuse yourself. So what does that mean? That then, do we really even need to hire a 7th judge for the court? If we have the option of a recusal, right from the word go.
Can I proceed?
Pardon?
I can answer now.
Yes, please.
Okay. So, recusal is probably the bottom in the list, my lady. I would insist that I should be taken for what I say and what I have represented, being objective. My relationship with His Excellency is not such that I always said yes to everything he wanted or he wished for. And so it has never taken my objectivity away. But I understand your question to be more of the perception of third parties. So again, I want to say that the front line is to say that I should be taken for what I represent, that I intend to be objective and fair, and that issue of recusal should be the last option. And even as I'm being put to task to answer that, I also want to insist that please take on board also the unfairness of the question and the unfairness of the concern just because of the person that I represented, a criteria that is not applied to other candidates.
All right. We just thought that it was important to bring to your attention what a section of the Kenyans are saying about your candidature.
I understand.
And you've given us your responses.
Yes.
The other concern, of course, was the fact that you've hardly been in the Court of Appeal, but I think you've discussed that in response to what the Chief Justice asked you. So now to my technical question. In a book entitled Cases That Changed Our Lives by one Ian McDougall, and in a scholarly article in that book, the scholar marvels at the wonders of the law, and I want to quote what he says: "Who would have ever thought that a partially decomposed snail in a ginger beer bottle would change the course of English legal history?" I'm sure you're aware of this case. A snail in a ginger beer bottle.
It doesn't come to mind immediately, my lady.
Wow. Because then my next question was going to be, yes, how did this case change the course of legal history in the countries that practice common law? Don't know you versus Stevenson?
Oh, yeah, of course I know you versus Stevenson.
Yes. What was the law before the snail?
I know the law that was developed in that case being that whoever keeps an item that causes damage to injury to somebody else is responsible for the damage that follows.
I asked the question, what was the law before the snail? keeping in mind the doctrine of the privity of contract. And if I may just remind you about the facts of that case, is that two ladies went to a cafe. One bought the two drinks, but Mrs. Donoghue was not the one who paid for the drink, and a snail was discovered in the bottle. And then the big question was, could she sue, and yet there was no privity of contract? She's not the one who had purchased the ginger ale. Are we together?
Yes.
Yes. So what was the law before then, and what is the law now?
My understanding of, I can't say for a fact I know what the law was previously, but I suppose considering what the law then developed in that case must have been that it is a condition for you to claim damages that there is a privity of contract, that you have to have a relationship with the person you are suing. But then the consequence of that case was that if you are offering a product, it should be probably in more developed law now, consumer rights. If your items cause damage or injury to somebody else, the fact of lack of privity of contract is not a defense to your liability for what you're offering to third parties.
So that is the law after 1928, but before 1928, you had to establish that there was privity of contract. Now, coming back home to the Supreme Court, what are some of the notable jurisprudential decisions that you can say have impacted our lives?
How many, my lady?
Pardon?
How many?
Give me 4.
Okay. So I think the most remarkable ones for me are 2. The first one is BBI. And the issues then were whether, in the name of amendment, the executive could torpedo the Constitution, or could replace the Constitution in the name of amendment. And I thought judiciary came out very proudly there to firmly put down their foot and say, we can only change the Constitution using what is there. And I thought that was a very momentous
so that is one.
Yes,
one.
2.
Yes.
Is the 2017 elections, August 2017 elections, where the judiciary distinguished itself in refusing to recognize the presidential elections. I did not and do not agree with the reasoning of the court then, but I thought even then we shouldn't miss the point of the independence of the judiciary in making that decision. I thought it was a very momentous and strong statement of the independence of judiciary.
I agree with you.
Yes.
Number 3.
The third one from the Supreme Court would be the finance bill. For quite some time, I know there has been pull and push between the executive and judiciary, and it entails questions of whether the judiciary is being activist, is overreaching, and is micromanaging the executive. The concept developed in that finance bill, suspension of declaration of invalidity, is a very important measure, because then it gives the executive time to adjust itself to the requirements of the circumstances of the situation.
All right. And finally, the 4th one?
The 4th one.